Ladies and gentlemen, in less than 24 hours, Delhi's Chief Minister has gone from bail to an extended stay in jail, from a potential comeback to a setback. The past 24 hours, ladies and gentlemen, have represented contrasting emotions for Arvind Kejriwal. The Delhi High Court today has put an interim stay on the bail order, which was granted to Mr. Kejriwal yesterday by the special court in Rouse Avenue. Now, this means that the Delhi Chief Minister, who was supposed to walk out of Tihar today, will be spending the weekend behind bars. But the real drama in the courts today was the ED's indignation over what the lower court has said while giving the Delhi Chief Minister bail. Mincing no words, the trial court observed that the Enforcement Directorate acted with bias against the Aam Aadmi Party. This is what the trial court has said. Accused the ED of bias against Arvind Kejriwal. The court also said that the ED failed to produce any direct evidence that linked Kejriwal to the much-touted 100 crore rupees, the supposed proceeds of crime. The court also made strong observations on the ED's contention in respect to the credibility of the approvers. This caused a very furious ED, represented by the Additional Solicitor General S.V. Raju, to take on the lower court with a vengeance. In the High Court, he labelled the trial court's decision to grant bail to Kejriwal perverse and riddled with serious procedural irregularities. The ASG further claimed that the trial court arrived at its quote-unquote malified decision to grant bail on wrong information and irrelevant facts, disregarding both the arguments and the evidence that had been put forth by the Enforcement Directorate. Now, stung by this latest twist that has kept its Supremo in jail, the Aam Aadmi Party, including Mr. Kejriwal's wife Sunita, has accused the ED of treating an elected Chief Minister as a terrorist and impinging upon Article 21 of the Constitution that guarantees him liberty. Listen in.
कल ही आपके मुख्यमंत्री को बेल मिली। अभी सुबह ऑर्डर अपलोड होना था, ऑर्डर अपलोड नहीं हुआ और ईडी हाई कोर्ट पहुंच गई ऑर्डर को स्टे करवाने के लिए। इतना ये तो ऐसे हो गया एज इफ अरविंद केजरीवाल इज द मोस्ट वांटेड टेररिस्ट ऑफ इंडिया। देश में तानाशाही इतनी हद पार कर रही है कि ईडी किसी को लिबर्टी भी नहीं देने के मुख्यमंत्री के अगेंस्ट वो स्टे के लिए चली जाती है।
कल जब अरविंद केजरीवाल को इन महिला जज ने बेल दी है तो इनके बारे में क्या-क्या आज हाई कोर्ट में कहा गया वो शर्मसार करने वाला है कि केंद्र सरकार की एजेंसी एक जज के विषय में ऐसा कह सकती है, ये कभी सुना नहीं गया।
Sabha elections show that the Delhi has unequivocally chosen Bharatiya Janata Party across all 7 Lok Sabha seats. And if you remember, the campaign of the Honorable Chief Minister was jail ka jawab aapki vote se. Even if bail is granted to the Honorable Chief Minister Shri Arvind Kejriwal ji, it is merely a legality. It does not show that he has been acquitted from the liquor scam.
Let me quickly introduce my guest to you. Karan Verma is an author. He's joining us on the broadcast. We'll be speaking on behalf of the BJP. Ashwini Kumar Dubey is an advocate from the Supreme Court, joining us as well. Ravi Srivastava is a political analyst. We'll be speaking on behalf of the Aam Aadmi Party. As you know, the Aam Aadmi Party doesn't send representatives to Mirror now. And Sanjay Hegde is a senior advocate. He's joining us on the broadcast as well. Mr. Hegde, I'm going to start with you. What are you most surprised with? Are you surprised with the fact that the Delhi High Court decided to put a stay on Mr. Arvind Kejriwal's bail, despite the fact that the Supreme Court is very clear and has very clearly, the Chief Justice of this country has very clearly encouraged lower courts, trial courts, to give people bail? So are you surprised that the Delhi High Court didn't take cognizance to it? Or are you more surprised with the line of argument and the ferocity of the argument that has been made by the ED in court today, calling the granting of bail a perverse order, malified in law.
Well, if you've been a lawyer as long as I, then nothing really surprises you. The point is that what was the tearing hurry for the ED to approach the Delhi High Court before even the order was uploaded? So obviously they filed an appeal without a copy of the order. And the Delhi High Court had an appeal before it. It said, okay, fine, let's not precipitate things. It waited for the appeal to be brought. In the meanwhile, the order was also available. And then based on it, they had a detailed hearing which went up till 4:30 in the evening. So you must remember that today, being a Friday, the court on a vacation, court staff also has to go up. So what the court seems to have decided is that, look, I will dictate a full order on this application for a stay, but that is going to take us a couple of days, possibly over the weekend. So we'll have an order one way or the other, either on Monday or Tuesday. And in the meanwhile, since the court had already stayed the release, that stay would continue. I do not read the final order in this interim order. I won't take the interim stay as indicative of what the Delhi High Court will finally do. But there is one thing that troubles me, and it is not only this case. I must recollect the recent cases in the Supreme Court, both in Gautam Naulaka as well as in GN Sai Baba, where when the courts below have granted bail, then there is an interim stay. And in Gautam Naulaka, the interim stay was finally lifted, and as well as in Sai Baba. So the point is that if any court has gone through the material and is within its jurisdiction and has granted bail, then why should an appellate court, in advance of a final judgment of the appeal, interfere at an interim stage? Courts should lean towards the liberty of the citizen. Here, courts seem to be sometimes giving the executive an extra long rope, and at times seem to be more executive-minded than the executive itself.
Okay, fair point to make. Ashwini Kumar Dubey, would you want to come in here? You're an advocate at the Supreme Court as well. What does our law say? Very simply, I'm not a lawyer. You are a lawyer and Mr. Hegde is a lawyer. But even I as a journalist know this. Children who study in class 11 and 12 know this, that under our law, jail is the exception and bail is the norm. Is Mr. Kejriwal a flight risk? I'm sure you will say no. Is he a terrorist, someone who will harm the country if he walks out of jail? Of course not. Then why make it personal? Is the enforcement directorate making it personal by running to the Delhi High Court when a trial court has already given Mr. Kejriwal bail? इतनी क्या खुंदक हो गई? इतनी क्या खुंदक हो गई ईडी को कि इतने बुरे दिन आ गए कि आप लोग ट्रायल कोर्ट जिसने बेल दिया उसको भी कोसने लगे?
श्रेया, जो जस्टिस कृष्णा अय्यर के आपने लीगल प्रिंसिपल्स कोट किए कि बेल इज अ रूल, जेल इज एक्सेप्शन, पीएमएलए is a special statute. And in this case, there are certain things which has been undergoing under the investigation. 1, 2, so far as the principles of normal criminal jurisprudence is concerned, granting bail does not apply here. 3, approaching to the appellate court against any order is fundamental right, is the statutory right within the legal domain of an individual and the agency as well. 3, here is the case where the vicarious liability, as has been argued by the enforcement directorate and has been accepted by the Honorable High Court, while staying the order of the trial court, has prima facie been found. Now 4, giving bail is admittedly is the discretion, is the wisdom of the judge concerned. Courts also, says the Supreme Court, that the life and liberty of an individual must be protected. But here, if we read certain paragraphs of the judgment of learned trial court, or what has been reported by the senior journalist of this country, the aware journalist, that says that the entire case has been said that nothing has been found against him. One. Number two, itself shows that he has been absolved from the liability. Number three, when the matter is still under investigation, the 45 crores alleged money trail, I'm again using the word very cautiously, the alleged money
Ashwini
trail,
ji.
which says has been
अश्विनी जी
allegedly
चलिए एक
used
बात सुनिए अब
by the Aam Aadmi Party in being the convener.
अश्विनी जी चलिए
See,
I
what will-
understand. तो आपने you are giving the PMLA की दुहाई and saying under PMLA bail is not the rule. सबसे पहले तो you are saying that. I will let Sanjay Hegde respond to that, but here's a limited point I'm making. The court specifically asked, and you are aware of this, the court specifically had asked, the court said that, look, no money trail has been established. There is nothing to link Arvind Kejriwal to this 100 crore rupees, which everyone keeps talking about. So he said, bhai, we need more time. ठीक है. How much more time? The ED couldn't answer that question. So are you telling me, Mr. Ashwini Kumar Dubey, that the ED has not been able to establish this trail for 2 years? Are you telling me that till the time they don't establish this money trail, say 3 years, 5 years, 8 years, 10 years, 20 years, whatever takes their fancy, or till whatever time the government doesn't change, आप अरविंद केजरीवाल को जेल ही में रखेंगे? अश्विनी दुबे जी, इसका जवाब आप दे दीजिए. पीएमएलए पे आई विल गो टू संजय हेगड़े.
बिल्कुल. देखिए, मैं श्रेया जी आपको फिर पूरे कन्विक्शन के साथ और पूरे आदर के साथ कहना चाह रहा हूं कि वाइकेरियस लाइबिलिटी और मनी ट्रेल दोनों में बेसिक अंतर है. दिस शोज दैट यूटिलाइजेशन ऑफ प्रोसीड्स ऑफ crime by a political party for during the election, that has to be established. One. Two, the PMLA again saying is a special दुहाई नहीं दे रहे हैं. श्रेया जी एक मिनट, आप प्रश्न पूछती हैं तो उत्तर सुनने का भी थोड़ा साहस रखना चाहिए. अब दूसरी सबसे बड़ी बात यह है,
अरे साहस से मैं क्या करूंगी सर, मेरा तो काम ही है आंसर सुनना, उत्तर सुनना. बोलिए.
अब एक कोर्ट अगर बेल देती है मैडम, तो दूसरी अपीलेट कोर्ट, विद ड्यू रिस्पेक्ट टू यू एंड माय रिस्पेक्टेड सीनियर मिस्टर संजय हेगड़े, राइट टू अपील अगेंस्ट दैट ऑर्डर इज द राइट एंड ऑनरेबल हाई कोर्ट. और हमेशा सुपीरियर कोर्ट का प्रिंसिपल यहां पर एस्टैब्लिश करता है. वेयर इज द क्वेश्चन ऑफ blaming, saying anything against the enforcement directorate या गवर्नमेंट? ये कोर्ट्स और कोर्ट्स के बीच में ऑर्डर हो रहा है. Where is the question of saying
look at what the
एग्जीक्यूटिव के इशारे पर हुआ? जी.
Look at what the enforcement directorate, how the enforcement directorate has badmouthed the trial court, almost making it personal. Anyhow, you have spoken about the PMLA, where you are telling me कि under PMLA इतनी आसानी से bail नहीं मिलता है. Sanjay Hegde, would you come in here?
Well, he is right that you do not easily give bail. But ultimately, you do have to give bail. Ultimately, in a case where the trial is not taking off, you have to consider it that after some time, bail has to be granted. Now, here, the court went through the entire evidence, and as prima facie, I found that, look, it doesn't appear as if the prosecution has a foolproof case. And that's why in granting bail, you know what the court also notes? The court noticed the submission made by the ASG on the credibility of the approvers, that investigation is an art. Sometimes one accused is given a lollipop of bail and pardon and induced with some assurance to make them tell the story behind the offense. So the ASG himself says, look, sir, we gave somebody a lollipop. He said something, and therefore that is our evidence. So the court says that if it is so, then any person can be implicated and kept behind the bars by artistically procuring the material against him after artistically avoiding withdrawing exculpatory material from the record. This very scenario constrains the court to draw an inference against the investigating agency that it is not acting without bias. So, I mean, this is a finding of a court that this agency, which says that I have the magic of the PMLA, where instead of khulja sim sim, it can say band ho ja sim sim, and afterwards no court can dare open the grant anybody bail. That is certainly not the law. And while anybody has
Karan Verma.
an opportunity to file an appeal, nobody has a right to an interim stay, because if a stay extends somebody's incarceration and later the case doesn't sustain in a trial, who is going to compensate? So the problem is that courts have to lean on the side of the liberty of the citizen. And I'm very glad that the trial court has taken heed of the words of the learned Chief Justice of India, saying that trial courts ought to be brave and grant bail. So here was a brave young judge who actually asked the law officer of the mighty enforcement directorate, come on, show me your case. And it has made its findings on the case. It will be very difficult.
Karan
Forget the
Verma.
stay part of it. It will be very difficult for an appellate court to set aside these observations at a later stage.
Okay, Karan Verma, by the looks of it, the ED has not even heard of Article 21. Okay? By the sound and look of it. Look at what the trial court has said. Now, the trial court is not, I mean, we can call courts political, etc., politically inclined, etc., but you can't accuse the trial court of being sold off to the Aam Aadmi Party. This trial court, a young judge, tells the ED, you are not acting without bias. That is Karan, that is something that is very clear to the people of this country as well. That the ED is not acting without bias. It is acting with a bias. It has made its fight against Arvind Kejriwal personal. How do you respond to that?
I think that is absolutely ridiculous. And I'll quote the Delhi High Court. I'm quoting the Delhi High Court order of 9th April. The material collected by ED reveals Mr. Arvind Kejriwal conspired and was actively involved in use and concealment of proceeds of crime. Another quote from the same day, ED was able to place enough material. We have gone through the statement which completes the chain and shows that money was sent to Goa elections. So this is the Delhi High Court.
Correct.
Now, I trust the Delhi High Court, right? Then another quote that I want to paraphrase.
Not the trial court.
When Arvind Kejriwal.
Not the trial court. Karan Verma, you are saying you don't trust the trial court.
I trust the Delhi High Court more. I trust the sense and the intellect of the Delhi High Court much more. Of course I do. I think that was absurd what came in the trial court. With all due respect, it was absurd. And what did the Supreme Court say while giving the interim bail to Arvind Kejriwal? That you should not go, and I'm paraphrasing that, I don't have the exact quote. You should not be allowed in the CM office, and that's why he was not allowed to visit the CM office. You should not be allowed governance because you can affect the turn of events. So I trust the Delhi High Court. I trust the Supreme Court far more in terms of intellect and judgment, not in terms of bias. And the Delhi High Court, while giving its order, has ratified that the process of ED is fair and transparent. Doubting the ED is doubting the judiciary. Those are the statements by the Delhi High Court on 9th April. So, it's very easy to pick and choose. The fact of the matter is, there is a 2,000 crore loss.
So, since you trust the Supreme Court more than you trust the trial court, Karan, right? Since you trust the Supreme Court more than you... Ek minute. Of course, all of us trust the Supreme Court, and more than the Supreme Court, all of us trust the Chief Justice of this country. So, based on that trust, the ED should have not questioned the bail that was given by the trial court, because the Chief Justice of India, in a function of the CBI, had asked the trial court judges to be brave enough to give bail. This is the Chief Justice of India. I'm not picking and choosing, bhaiya. Jo bola hai, wo bola hai. And I'm not the only one saying it, by the way. Acha, how am I picking and choosing? Batao.
I'm telling you, there is a context to it. Not if you can influence the investigation, as the Supreme Court said while giving interim. The Supreme Court said you are capable of influencing the outcome. That is why you are not even allowed to go to the CM's office. Itni badi baat bol di Supreme Court ne. then you can't grant
लेकिन
him
दिया
bail.
ना सुप्रीम कोर्ट ने बेल.
Interim bail.
अरे भाई
Interim
सुप्रीम
bail.
कोर्ट ने तो बेल दिया था ना. Ravi Srivastava, would you want to come in
Interim
here? Okay. Ravi
Interim
Srivastava,
bail,
would you want to
not
come
bail.
in here?
My friend is
ठीक है.
clutching to some observations which were given at the time of bail, which were very normal and which were given to anybody who is being granted a bail. He will not temper the evidence. He will not go to the office. He will not talk to the people. He will not talk to the press. He will not do this. These are all standard practices while a bail is being granted. There is nothing serious in it that, oh, you can't go to CM's office. You will do it there only. No, what I want to say here is that let us not get into two things. We are mixing up the two things. We are talking about the trial of the case and we are talking about the bail. What the lower court did yesterday was she went through the whole gamut, but she said that I am not getting into the evaluation of the evidences, all those things, because it is not the stage. It is a stage where this man is required to be kept in the custody or not. He can go out. You can go the trial. You can do the trial. The trial will go on, which is a long process. Charge sheet has been filed. Evidences will be evaluated. अरे 40-45 करोड़ गोवा में खर्च हो गया. बाकी 60 करोड़ कहाँ चला गया? This kind of questions. Chat दो चैट है. एक चैट में हैप्पी बर्थडे किया. एक चैट के अंदर एविडेंस बैठने के लिए अपॉइंटमेंट मांगा. वो चैट एविडेंस हो गई है. तो ऐसे such flimsy evidences are being shown. That is why the honorable judge has arrived to the conclusion. And what learned advocate Sanjay Hegde rightly said it, that investigation is an art. I think it is a sad commentary on this country's institution, a prominent institution. It's an art, really, because it's an art. When Chhagan Bhujbal case, the file goes missing, the FIR goes missing. The ED says, no, we have no case. In 45, section 45, you have only two reasons. One, ED does not oppose your bail. Second, the person is found innocent, no case is found against him. She relied upon the second part. She found that there is nothing sticking on Arvind Kejriwal. She granted him the bail. So this is, and now after it has gone to High Court, Appellate Court, I do not find the High Court has only allowed, okay, you say whatever you want to say, what you could not say in the lower court, you say
Mr. Srivastava,
they said everything. And now it is over.
Chaliye, Mr. Srivastava, we'll see. You know, the point is that what's making headlines is, of course, the fact that Mr. Kejriwal was supposed to walk out of Tihar jail today. The Delhi High Court has put a pause to it. Has it done the right thing? Well, it's the court. It can do anything it wants. But if a trial court has already given him bail, why pause it? You can keep hearing the matter. The ED has every right to go to the higher court. You can keep hearing the matter. Why pause it? We'll leave it there for the moment. We'll see what the Delhi High Court says on Monday. Thank you very much for joining us, Ravi Srivastava, Sanjay Hegde. Good to have you on the show. Ashwini Kumar Dubey ji, thank you very much. And Karan Verma, thank you very much. Ladies and gentlemen, on that note, I'm slipping into a break. There's much more on the other side that is putting a big question mark on one of India's institutions. That's the NTA. That story coming up next. Do stay with us.